central government today took exception to the protest march conducted by Delhi Chief Minister Arvind Kejriwal yesterday against Delhi Lieutenant Governor Vinai Saxena during the pendency of a case before the Supreme Court of India in relation to the dispute between the Delhi government and the Delhi Lieutenant Governor. Solicitor General of India Tushar Mehta, appearing on behalf of the central government today, told the Supreme Court that such protests and theatrics cannot be a substitute for legal arguments. Arguing before a constitution bench of the Supreme Court comprising Chief Justice of India D.Y. Chandrachud and Justices M.R. Shah, Krishna Murari, Hima Kohli and P.S. Narasimha, the Solicitor General remarked, and I quote here, "Certain events are happening when your lordships are in the midst of the matter. Some protests, etc., which constitutional functionaries would always avoid when the matter is before your lordships. I would not answer, but if your lordships would like to know the facts, we are always open. But we thought we would confine to legal and constitutional submissions only, because protests and theatrics can never take the place of submissions before the constitution bench." So what exactly is this ongoing legal battle between the centre and the Delhi government, and what does the Supreme Court exactly have to decide now? The issue in dispute before the Supreme Court concerns the scope of the legislative and executive powers of the centre and the Delhi government over the control of administrative services, which include appointments and transfers in the national capital. Interestingly, nearly 5 years ago, another constitution bench of the Supreme Court had ruled in favour of the Aam Aadmi Party-led state government in a similar dispute. As many of you might already be aware, Delhi enjoys special status in India, being a union territory with the features of a state having an elected legislature. Article 239 of the Constitution empowers the Lieutenant Governor of any union territory to act independently of the Council of Ministers. However, in the year 1992, through the 69th Constitutional Amendment, the Parliament inserted Article 239AA in the Constitution, which mandated an elected assembly for Delhi. According to this provision, the NCT of Delhi will have an administrator and the legislative assembly. The provision stipulates that subject to the provisions of the Constitution, the Legislative Assembly shall have the power to make laws for the whole or any part of the NCT with respect to any of the matters in the state list or concurrent list, insofar as any such matter is applicable to union territories except on the subjects of police, public order and land. Owing to this, in the recent past, governance in the national capital has been a subject of conflict between the Delhi government and the Lieutenant Governor many a times. Before we delve into the legal dispute in detail, let us first understand how the Chief Justice D.Y. Chandrachud-led Constitution Bench came to hear this dispute in the first place. On May 6th last year, a three-judge bench headed by former CJI N.V. Ramana had referred this case to a larger bench on the centre's plea. The three-judge bench of the Supreme Court had decided that the question of control over administrative services required further examination. The centre on April 27 last year had sought a reference to a larger bench, arguing that it needed the power to make transfers and postings of officers in Delhi on account of it being the national capital. The three-judge bench had noted that the primary contention involved the interpretation of Article 239A, Clause 3, Subclause A of the Constitution, which deals with special provisions for the NCT of Delhi. The bench agreed that the limited question relating to the scope of the legislative and executive powers of the centre and NCT of Delhi with respect to the term services would need an authoritative pronouncement by the Constitution bench in terms of Article 145 Clause 3 of the Constitution. For context, Article 145 Clause 3 basically deals with setting up of a Constitution bench comprising at least 5 judges for the purpose of deciding any case involving a substantial question of law as to the interpretation of the Constitution. Now, how did the case exactly come up before the three-judge bench headed by former CJI N.V. Ramana? The case had come up before the three-judge bench because a two-judge bench of the Supreme Court had earlier delivered a split verdict on the issue of services. In this judgment delivered in 2019 by a two-judge bench of Justices A.K. Sikri and Ashok Bhushan, several issues relating to the powers of the Lieutenant Governor had been settled. However, on the issue of control over services, the two judges had ruled differently. Due to the split verdict back in 2019, the case had been assigned to a larger bench for adjudication. The 2019 verdict was essentially delivered to decide the contentious issues based on the law settled by a five-judge constitution bench back in 2018. In 2018, a five-judge constitution bench comprising the then CJI Deepak Mishra and Justices Sikri, Bhushan, A.M. Khanwilkar and now CJI Chandrachud, while interpreting Article 239AA of the Constitution, had stipulated broad parameters for the governance of Delhi and had held that although Delhi cannot be given the status of a state, the powers of the Lieutenant Governor can be curtailed as he has no independent decision-making power and has to act on the aid and advice of the elected state government. The bench had also restricted the jurisdiction of the Lieutenant Governor to matters involving land, police and public order, while holding that for all other matters, he will have to act on the aid and advice of the Council of Ministers. Now, prior to this, the Delhi High Court, on the contrary, in its judgment dated August 4, 2017, on the same issue had held that for administration purposes of the NCT of Delhi, the Lieutenant Governor is not bound by the aid and advice of the Council of Ministers in every matter. The Delhi High Court was basically dealing with the conflict back in 2015 between Delhi Chief Minister Arvind Kejriwal and Lieutenant Governor Najib Jung over the appointment of the Chief Secretary and the institution of corruption inquiries. The Kejriwal government had subsequently challenged this particular Delhi High Court decision in the Supreme Court, which had referred it to a constitution bench. Thank you. I'm Arvind for LiveLaw. Keep watching LiveLaw for more such updates.